claim under the 1975 Act. And so the Act itself actually sets out the categories of people that can bring a claim. That includes the surviving spouse or civil partner, any children of the deceased, anybody treated as a child of the deceased, some categories of people who could be considered to have been maintained, some cohabitants and some former spouses, providing that they haven't remarried and that the terms of the divorce don't preclude them bringing a claim. There's obviously far more scope for dispute when it comes to categories like treated as a child, maintained, or cohabitant. And there's, through case law, kind of strict criteria that's been set out as to whether or not somebody's eligible to bring a claim under one of those categories. Very broadly, when the court looks at it, those treated as a child have to demonstrate that the deceased assumed the role of a parent at some point in time, some kind of responsibility. Cohabitants have to show that they were living together with the deceased in the same household as effectively husband and wife for at least 2 years immediately before death. And those being maintained have to show that immediately before death there was some kind of maintenance being provided by the deceased, and they assume some kind of responsibility towards them. As I said, this can often be a dispute in itself, and where there is a dispute as to eligibility, the court can decide that as a first issue before the substantive claim is even brought. And it's also really important to be aware that even if you are allowed to bring a claim, or you succeed in being entitled to bring a claim, it doesn't mean that you're actually going to succeed. It's just the very first step on that hurdle.